the CEO Legal Coach here, licensed attorney and longtime business coach and consultant. Today, we are going to walk through a mutual non-disclosure agreement. Well, this one happens to be a mutual one. A non-disclosure agreement that I got from another company, just as if it was sent to me. What I do when I look through one, like what am I looking for? Why am I going to make a change if I don't make a change? And so on. Now, this one's not really prepped to be or call out anything specific. It's just an actual third-party NDA that I had permission to do this with. So I'm just going to walk through what I would normally look for and talk out loud why these are the things that I am looking to do. So let's just dive right in. Let me get over to that screen for you to share that. And here we go. So we have first and foremost a mutual confidentiality agreement. This is important. I always first check if it's a unilateral or a mutual confidentiality agreement. Because in business, unless I have an actual reason to be in a unilateral NDA, I want this to be mutual. And I would push back if they had sent me a unilateral one. Why? Unilateral means only one party's information is being shared. And to me, if this is going to be an equitable relationship, which of course will develop and grow over time with trust and business opportunity and growth, both parties will be sharing information. And I want to know that my information is going to be just as protected as theirs. So that would be the first thing I look for is, am I in a mutual or a unilateral NDA? Now I'm going to look at the effective date. Effective date, want to make sure that is the correct year. And because sometimes if they're using a template, it's not always updated accurately. And if information has already been exchanged for whatever reason before an NDA has been signed, I want to make sure that this date is going to cover those dates as well. But otherwise, just whatever date it is fine. Entered into, by, and between. First, I want to make sure that my entity is on there correctly with my information, in which case this time it is beautiful. But then I'm going to look to the other party. And I'm going to look to the other party for a few reasons, and I really, really love this because one of these stands out right here. Amco Alternative Limited on behalf of itself and its affiliates. So I am going to go like this. I think I'm in red lines. For some reason, my red lines are not showing. I want to make sure that they are showing for you, so it's off tracking. Okay, so I'm going to ask that be removed, right? And we've got this red line here to show that. Why? On behalf of itself and its affiliates. So which means its affiliates are going to be a legal entity that have permission here. And I am like, why are they on here? I am not doing business with your affiliates right now. I'm doing business with you, Amico. So I would delete that, and I'm going to add a comment that says affiliates are not part of this. Arrangement. Please explain why they are added. Right? So I'm saying they're not part of this. They don't belong there. And they may have put it there just out of default, might have been their template, or they might be trying to expand. Maybe they can't do this work on their own. Maybe they need their affiliates and so on. But then what do I want? I want to know who is going to legally have rights to my information, but also who is responsible if they breach it. Because when we have an affiliate situation, if they can go share that information with their affiliates, I'm not under legal document or under contract with that affiliate. So I would have to sue them through Amicable Alternative to be responsible for itself and its affiliates. And I don't want that. So I want to know, one, who has my information and why. Two, that it's going to be used properly. And three, who's responsible for what here. So 9 out of 10 times, no affiliates or anybody else should ever be there. And so I'm going to push back on that. Everything else looks good there. All right. Entering a business with exploring, entering a business relationship. That's the purpose here. The business is exploring, entering into a business relationship. That's not bad because it is true. That is what we're doing. We're exploring whether or not we want to start working together. But it's still really vague into a business relationship. Well, that's really big. So, exploring, entering into building a website together. I want to limit what they're going to do with my information. And I want it to be narrow because any business relationship or any business use is very, very broad. And they could add things into that. They could read into it and say, well, we're going to go take this information and try it in our other products or our other business lines to see if it's possible to enter into a business relationship over that. And that's not why I'm giving them access to my information. I'm giving it to it for this particular purpose. So I want to narrow that down. All right, this is all pretty standard confidential information. I'm going to look at a few things here, what it includes. Bam. So make sure what I need to be included in there is there, but also seeing if they've put anything wonky in there, because I'm going to be responsible for their information because this is a mutual NDA. But before we get that, I do see we have representatives and affiliates defined here, which gives me a clue that they're going to try and share this or get permission to share this beyond them, beyond their employees. So let's see what this says. By either party to the other recipient or its affiliates, which again, I don't want them in there, or to any such employees, directors, shareholders. Why do your shareholders need my information? Right? Members, same thing, because members usually are in the same type of category. Managers, agents. This is somebody that represents them. There are times it makes sense for that to be there. My use case of a website, I don't think they do. Independent contractors. Okay, I want to be mindful of this, but I can understand why in the website context, they might have independent contractors. So I'm going to be mindful of this a little bit later, but it's good to know that it's there. Service providers, the same thing. Sub-licensees. They're not allowed to sub-license my information here. And even if you had a product or something like that, being mindful of that. Sub-licensees. Why do their sub-licenses need access? Subcontractors, for me, are going to be in the same category as independent contractors. They're attorneys, accountants, or financial advisors. Okay. Very, very strong unlikelihood of any of this. So I'm going to take this out. So now I've limited who they can share my information with, because I want to make sure it's only who might actually need this. And in the event they need to expand that list, we can always enter into an amendment later, or they can come get my permission. But I don't want to just automatically grant it unless I'm aware there's a reason. Okay, whether disclosed orally or accessed in written, electronic, or other form, awesome. And identified as confidential. Ooh, I don't like that. Because here's the thing, when I'm talking to them in a meeting or at a lunch or at a cocktail hour or something, I'm not going to say confidential before everything I ever say. And see, when we're in our meetings, when we're in our calls about the design and content of the website, I'm not going to say, hey guys, don't forget everything I am saying is confidential. Because that's what they're saying is I have to disclose this as confidential. And I'm going to have to also mark that in every written, electronic, or other thing as that. So I can appreciate that they want to know that. But I'm also going to say, or a reasonable person under the circumstances would consider the information confidential. So that is one way I can do it. But what I actually prefer is I want something even broader than that. And I am going to say whether or not identified as confidential. Now, there isn't a scenario or any trigger or condition about it. It simply is whether or not it is confidential, as defined, as we'll get to in a moment. An affiliate with respect to any party, okay, cool. If we have affiliates involved, I understand why we want to define affiliates. You want to understand, if there's controlled or controlled by, then there's sort of this ability to pierce that legal entity to getting to the other one, because they ultimately are going to have the final paperwork, taxes, assets, and responsibility. But I would define that further, like something like has at least 51% ownership or something like that. Because otherwise affiliates can be very loose. It could even sometimes mean a joint venture, which is with a third party, a literal other company. And then, so being careful about that. But I'm going to go ahead and make that comment here. affiliates are not understood to be part of this agreement. So then they understand why you removed them, and if they want that back in there, they can explain to me how the affiliates belong there. All right, confidential information includes all information, business, marketing, sales, other commercial strategies, content, plans, right? Because this is about patents, IP, that is about technology. No, not that portion of, we're just going to flat out say all notes. Okay, so this is talking about the derivatives. Like when you get information, sometimes you have to make notes about it, or you're deciding, you don't just read it, absorb it, and walk away. Sometimes you be like, oh, I think this would work with that. And sometimes you try things out. You create the trial and error, or the notes, your review notes, or your sharing notes, your conclusions. And so that's what this is referring to here. I do like that. But it is lacking what I'm going to have in my website. Now, once, of course, things are on the website, they're public. But until then, they're not. And I don't want them giving that away. So with element of financial customer information, supplier products, services, marketing copy, images. What else might be on there? Code, branding, and other non-public. Website, product, services, and business plans. All right, so now I've made sure what I need is going to be in there. Beautiful. Okay. Exclusions from confidential information. There's these key 4. Because required disclosure, or there's after it becomes generally available, known by the public as a result of, unknown to the public, other than by a result of. The disclosure that was by documentary evidence. See, I usually look for this here because I don't want anybody to just be able to claim it. I want them to have evidence of that. In fact, I want to put that right here, as well as established by documentary evidence. It's not enough to just claim it. You actually have to be able to demonstrate that was a reference to or use of, in whole or in part, any of my information. Okay, so these are the 4 standards. These are in pretty much every NDA in some form or fashion. So nothing too crazy there, or okay, yep. The obligations of the recipient, protect and safeguard, but no less reasonable care. Okay, so there's no specific standard. Not use a disclosure, confidential information, or permit it to be accessed for any purpose other than the purpose, or any related transactions. No, for the purpose and the purpose only. I don't want any other related transactions. I don't know how they're going to interpret that or what they mean by that. So I'm going to take that out. That does not belong there. Between the parties or otherwise in any manner to the disclosur's detriment. No reverse engineering, decompiling, disassembling. Okay. So any person or entity, this is where, remember how earlier we saw that they had in their representatives, they had listed independent contractors, service providers, and subcontractors, attorneys. These are usually third parties, right? They're not ones that they have ultimate control over. So what I want to know is make sure that they are not allowed to disclose this to any of those people unless they need to know that confidential information to assist the recipient or act on his behalf in fulfilling the purpose, or to exercise his rights under the agreement, that those people be informed by the recipient of the confidential nature of my information and are subject to confidentiality duties, obligations that are no less restrictive. Okay. I'm actually going to go one more. I'm going to throw one more in here. Such recipient, except to the person who, for drafting purposes, Sorry, I'm so used to doing these in silence. I don't usually talk out loud when I do these. Recipient. So what I'm doing right now is it says that they can give the information. What I'm going to do is I want to limit how much of that information I can give them. Just because somebody might be there to help you with the purpose doesn't mean they need all of the information. A great example is, let's say somebody needs access to financial books. So maybe there's an Excel sheet with like 10 columns. Well, if they only need to use 3 of those 10 columns, then guess what? The other 7 they're not going to get access to. But as this was sent to me, they could just share all 10 of them and be like, whatever, they're going to use 3 of them, we can send them all 10. That's an overshare, but that overshare would be permitted under this NDA. So I'm going to add something to limit that. Recipient shall disclose any such confidential information only to the extent necessary for any such representative to support recipient in fulfilling the purpose. So I am limiting that there. Now, you're probably going to ask me, where am I using these words? So recipient was defined earlier. And anytime there's a defined word in a document, we capitalize it. So that way we know that I am saying, when I say recipient, I mean recipient. And recipient here is when confidential information is shared by one party, that party who's giving the information is the discloser, to the other party. The other party is the recipient. And that recipient's employees, directors, and so on are called the representatives. So that is what I am adding here. I am clarifying that the recipient, the person who receives the information, by person I mean the legal entity, so the company, shall disclose any such confidential information only to the extent necessary for any such representative to support recipient in fulfilling its purpose. So recipient, the company who's receiving the information, shall disclose any such confidential information as defined in this agreement only to the extent necessary for its representatives to support it, recipient, in fulfilling the purpose, which was the use case that I have approved here. So that's what that is doing. That is why those words are capitalized and the way that that is formatted as a sentence, because normally in just plain colloquial English, that would be a weird sentence. Okay. Be responsible for any breach caused of this agreement caused by itself or any of its representatives. Notify the discloser. This is one of those, you could have it either way. Notify discloser, because that means a defined term already. Right? The person giving the information, but you could also that way. But it is cleaner to have it without the word the. In writing within 48 hours of any misuse or misappropriation. Okay. That's a quick turnaround, but I like it because it's also in my favor. So if I were to find out of any misappropriation or misuse, authorized access to, so it's not just the misuse or the misappropriation, but the unauthorized access to my information. Just because it hasn't been misused yet doesn't mean that person or third party, that the recipient is in violation. They've breached it. Somebody has had access to my information. And I want to be notified of that. That comes to their attention. This is one where I have had pushback from big companies on this. What some big companies like to do is say, after our internal investigation is complete, or after we've done an internal assessment, after policies. The challenge with that, having been on both sides of that, is that when a company does that, they're saying, hey, we're going to take care of ourselves first. We're going to see what our legal liability is here before we share it with you. We're going to learn what really happened, right? Sometimes you can tell there's a breach, but you don't know where the breach happened, especially if it's a data breach or a hack or something. That's very, very possible. 48 hours is not enough time to have complete information. And that sometimes does not matter right? In this case, it's website information. So I just tell me within 48 hours should be good. But there's other times the second you're notified, like under privacy laws, you trigger something under the law. A lot of laws, privacy laws, I think both in the GDPR as well as some of the states, I believe California might be one, where once you find out there's a breach of somebody's personally identifiable information, you have to tell the government. So that would mean you've got to go tell the government and you don't have all the information yet. That can be a really wonky place to be because depending on what got shared and who it got shared with and how it got accessed, that can be really dangerous for your company. And you want to know ASAP. At the same time, though, if you find out and that you now have an obligation to the government or to another supplier or something else, because what if it's not all of my information? What if my supplier's information's in there? What does my supplier agreement say? I have to tell them. So being mindful of these timelines and what they are based on the information at hand and how that would play out practically, should you find out that somebody else has had a breach, what does that mean for you and your obligations upstream, either under law or to your suppliers? But this is website information, so that does not apply here. But if there were certain industries I've been in, like finance, healthcare, data, privacy, tech, that might be a big trigger. So being mindful that you're able to have the information you need before you proceed, but at the same time, not leaving a blind spot because you didn't write the contract correctly there. But as you can see here, it doesn't have to be anything profound. Just tell me within a certain time frame of any of these types of things. Misuse, unauthorized access, or misappropriation. Cool, right? Okay, additional confidentiality agreement. Obligations, except as required by federal law, shall itself not disclose any of it or nor permit any of its representatives to disclose to any person that the confidential has been made available or that has inspected it. Okay. This one's a little bit more in depth than what we normally see. Normally, it's just the information being disclosed, shared between the parties. But this one is saying that we also are not allowed to share to anybody that we're making it available to our representatives or that we've looked at. I don't get to go be like, yeah, hey, potential website designer, I've looked at so-and-so's back end and how they do things, and I'm not liking, I'm in violation right there. And, or that discussions or negotiations are underway between us. I had a sales rep once who was going off and telling me, yeah, hey, we're in talks with so-and-so. So if you want to get in on this price, you better hurry up because so-and-so is going to come in. Well, that was a violation of the NDA, and that other company came back and said something. So being mindful that this is one of those NDAs where I can't even talk about that. Again, I have permission here, but that would be a violation, right? To share this with any of you or share this document even with anybody that I don't need to for the purpose would be a violation of the NDA. And that we're in. Okay. So it's good to know that I don't mind those things because it also benefits me in this case. But it is something that if I wanted to make a big press announcement or say, hey, this website was designed, but like the number one company and blah, blah, I'd have to get permission from them. Required disclosure. This is one I always look at. This is one of those areas that when you're required under the law or court order or some federal agency, state agency, government agency to do something, to give them information, to disclose something. Maybe there's litigation going on and you just happen to be a party who has information. You're not part of it. You're just somebody who has information. Well, they're going to come be like, well, you have to give us this. And my response is going to be, well, I'm under an NDA. It's a breach of contract for me to give you that. So what is really good is to look at how that plays out practically. And that's what I'm doing here. So any disclosure under a valid legal issue, okay, it should be subject to this section. So this is what are going to be the required steps and processes. And I'm going to guess there's going to be some type of notification requirement here as well. So before making any such disclosure, the recipient shall make commercially reasonable efforts to, or to the extent reasonably possible, to do the following. So what this is saying is I can't, just because the FBI comes along and asks me for information, I can't just give it to them. I have to follow these steps. Otherwise, I will be in breach of the contract. I have to give prompt written notice of that legal order to the discloser so that the discloser may seek at its sole cost an expensive protective order. And I don't like that because that requires that I tell them, well, what if I am prohibited by law from doing so? Prompt notice to the extent permitted under law, order, or other regulation. Because there are times where there's an investigation going on, and they may say you can't tell them that this investigation is going on. So I'm right back to being stuck in the middle. I want to comply with this federal agency during their investigation so I don't get investigated. But this said, I have to tell the other side. So I've now said that I will give them prompt written notice to the extent permitted. If it's not permitted, I don't have to give it. And that they may seek at their sole cost. So this is really important here too, because if they decide to say, they may come back and be like, whatever, it's okay, just give it to the FBI, we don't care. But they might say, hey, don't give it to the FBI, because then it might become public awareness. For example, in court cases, a lot of times stuff in court is publicly available. That's the thing. It's court, it's public. So there might be something in some of their information that they'd be like, hold up, we want to at least talk to the court, see if the court will seal some of this so that they can use it in court, but that it won't be part of the public record at the end. They're going to seal that, and that's done with a protective order. So that's what's going on here. These guys want to have the ability to go get that should they want it. And of course, I get the same rights. If I find out they have to disclose something of mine, I have the choice. And that I have to give them reasonable assistance at their cost and expense, in opposing or seeking. I have mixed feelings about that, but because they put sole cost and expense, and it's a reasonable assistance, they didn't say that I had to get full assistance, just reasonable assistance, I'll let it go. But that's what that is about. So pretty good. I just want to make sure I have this carved out so I don't get stuck between a rock and a hard place again. And if after providing such notice and assistance as required herein, the recipient remains subject, the recipient shall disclose no more than the portion of confidential information requires. So same thing that I held earlier with the recipients getting the information, right? You don't just get to give all 10 data fields if they only need 3 of them. That's what this is saying too, is if the FBI or the court or the agency only needs 3 of the data fields, you only get to give them 3, not all 10. Okay. So that completes that. Return or destruction of confidential information. So now it would appear that most of the obligations are over. Now we're going to start looking at what would happen at the end of this NDA. At any time during or after a written request, they shall promptly return all copies, destroy all such copies, and certify in writing. So it's a certificate. So there is a legal obligation here, contractual obligation to certify. Certification of return or destruction, either upon written request, at any time, during or after. Then certify, and in addition, the recipient shall also destroy all copies of any notes and things related to it. Destroy all copies created and certify it. Okay, that's what I wanted to make sure it was there. They could have made both of those in one sentence, but no biggie. I'm just repeating it for the information plus the notes, but same. Okay, notwithstanding the foregoing, neither shall be required to destroy all electronic copy that is created pursuant to its standard. What I'm trying to think through right here is, so this is giving them a carve out. that, look, we have to return or destroy everything to you and certify that. However, we do have the right to retain copies. This is really, really common because when we have archival backup systems, right? Like, let's say your systems automatically back up every Sunday night at midnight and they go to some server, some cloud somewhere, right? You're not accessing those. But that's part of your everyday system to have backups because backing things up is important. Well, what that means is that you have these backups. And it can be difficult to say, well, we've got all these backups for, let's say it's a 2-year NDA term. Do we have to go back through every single backup over 2 years and delete it all? And so what we're saying here is like, no, you don't have to go back and destroy those at this time. However, we want to make sure that information is not accessed. That if it is accessed, it is only accessed by the IT people, and they cannot use it for any purpose other than its backup. And then we want to make sure that it is destroyed as those backups are destroyed. And this is really common, not just in the backups, but certain industries are required for compliance purposes to keep and retain records. Sometimes a lot of companies have a document retention, just like you have to keep your taxes, right? You file your taxes and you got to keep copies of those for 7 years, just in case the IRS comes along. It's the same with businesses. So there are certain things they might have to demonstrate. They had a certain transaction, they had a certain contract, certain information did or did not go across their servers. This type of information might be inquired for litigation, a state government agency, a million reasons whenever we have investigations under the law. And so just making sure it is there is important to their legal compliance. They have to have that on hand. And so they're going to create those carve outs in their contracts, including their NDAs. And so I'm going to look at this. I'm not going to be too refined about this because of the information that I have here. But there are times I will get seriously nitpicky about these, about how long it could be there, when it has to be destroyed, that they have to notify me across those destructions, and so on. So just because they have a backup doesn't mean they get to say, well, I've had it's in backup. Therefore, we get to keep it for 40 years. Like, no, there's no law that says anybody needs to backup stuff for 40 years. When you're required under law to no longer have it, guess what? You no longer have it. So I would normally care that much in here. I'm not going to go into that level of detail, but those are considerations that I would usually look at in this type of a section. It's going to be asked by any employee, representative, or representative other than Sanel. I think this is already kind of stated. Let me reread this. Okay, not primarily. It's said in the negative here. Not primarily information technology in nature and do not have access. So I've further this. So I'm limiting that it won't be used for anything else. The recipient and its representatives may retain to the extent required to defend or maintain litigation. Okay. Shall destroy and certify in writing. I'd usually clean that up a bit more. But I also want them to know that they still have to destroy it. Right? You don't get to keep it in backup form forever. And I'm going to copy paste this into here. Man, they have a lot of mess ups in this thing. Okay, one copy to the extent required to defend litigation. Just copy to the extent required. Provided, however, the recipient shall continue to be bound with conditions of this agreement with respect to routines, including but not limited to any obligations of return. Sorry for all these typos, guys. Okay, but not limited to. So now we're through those portions, and you can see why I've put these in here. And this is really great because if you see somebody redline yours, you can understand what they're after, right? I'm not trying to change the rules here. I am trying to clarify them. I'm not saying what they want is bad, but I am saying I still have the right to these things, and it still makes practical sense. And if they don't want to agree to that, I would like them to explain to me why. And then I could decide, do we need to have a phone call about this just to understand it more? Am I okay with it? Oh, that makes sense. Okay, yeah, sure, just leave it at that. Right? These types of things are what a red line leads to. It is not a fight. It is not an argument, especially because this is a mutual NDA. Anything I'm asking of them, they get from me and vice versa. Now we're on to the term. The term of this agreement and shall expire 3 years from the effective date. Okay, provided that either party may terminate this agreement at any time. Awesome. They're providing written notice, notwithstanding to the contrary. Each party's rights and obligations shall survive any expiration of term of this agreement. I don't like that. I don't like having a set term, because what if my information is still confidential 5 years from now? Or let's say 6 years from now, because we have a 3-year term and 2 years after. 6 years from now, some of my information probably isn't confidential anymore. The other parts might be. And just because a time frame has run out does not waive my rights. So I don't want them to have that. This is something that I get people to push back at a lot. For companies that put, there's 2 schools of thought on this one. For companies that put a timeline in, like they just did in there and I removed it for 2 years after, they are likely to come back and be like, hey, we need to know when your stuff's no longer confidential. And I'm going to say, my stuff is confidential for as long as it's in your hands. It is not your decision when my information may or may not lose its value. It's my decision. So I give you 2 choices. At the end of this NDA, when the term and termination have come up, you have 2 choices. Choice 1, return and destroy everything, right? That's what is agreed to already. And standing, provided that either party may terminate this agreement at any time upon termination, recipient shall return or destroy all confidential information and notes in its possession. By the way, most NDAs don't separate notes from confidential information. It's usually just all in one definition. Shall return or destroy all confidential information and notes in its possession and shall certify in writing. Shall survive. So now I've just flat out said, upon termination, you've got to do this. You have to return and destroy it and certify it for me. Plain and simple. You're not allowed to have it. And if you do need to continue having it, it's under these terms we have up here. Right? Because it's not, the reason I am not relying just on this is that this requires me to remember to send a written notice. At the termination, I want it to automatically trigger that they have to return and destroy my stuff. Automatically trigger. Whereas if I leave it to this portion up here, it says upon my written request. I have to remember to write them. By the way, please do this. Now, I'm still going to make a note in my documents, in my calendar, that says on this date, this NDA ends, I am going to send them a letter that says, please return and destroy my information. But just in case, I want there to be an affirmative obligation. I, too, now have this affirmative obligation in respect to their information. So that is in there. Each party's obligation shall survive. Yes, and with respect to constitutes a trade secret. I normally fight back on this one. I'm not leave it alone. Why? Because I don't want them deciding when my trade secret has lost its protection. I want to be the one who decides that, not them. But the way it's written, it's not end of the world, especially because I have these other things. So now that really ends the core of the document. We're going to get into now the time and money savers. Some things that these are going to clarify so we don't end up confused. If something goes wrong, these are going to save us time. They're also going to save us a lot of money, because when you have to go to court or you have to go to arbitration or you go wherever and you end up having these situations, sometimes even which court do we go to can end up costing 6 figures. Right now we're finally in court and we can start and we've already spent 6 figures. So getting to our answers quicker and faster whenever we need to seek that third-party help, these are going to help us do that. So no representations or warranties, very standard. No transfer of rights or title. Love it. No other obligations. Yep, not even to disclose. Good. Okay, remedies. Usually pretty standard, but let's check it out. Not be sufficient. Therefore, in addition to all the remedies available at law, which neither is when the non-breaching party shall be entitled to. Ooh. I'm going to go with seek on that one. They left it open. Specific performance and objective other or threatened breach, yes. And the parties hereby waive any bond. Yes. Okay. Very standard there. Further agrees it will not oppose. Wow. Yes, it should be a reasonable non-major forcing. Yeah, mixed feelings about indemnification, but I am okay with that. Governing law. Okay, let's see what state or country they want this agreement in, because I'm in Nevada and they are in California, if I recall. Yes, California. They're in California, right? So Amical Alternatives in California. I am in Nevada, so they likely have listed California law down here, or they've picked another jurisdiction. Let's see, governing law, state of California. Okay, I am not going to agree to that. I do not want California at all. Why? I don't want California's laws. California is what is called a statutory only. So the law doesn't really have the same living element. And each time you bring up the courthouses, so when you bring up something in court, it is like the first time it's being seen. It's different approach to how you would demonstrate a case, demonstrate the ability to win a case, and so on. So not only do I not like my ability to fledge out a living document, because NDAs are something that's definitely living, and we have information, so technology, privacy, all these things are changing over the lifetime of this NDA, and I don't want what may or may not be in California statutes about that to be what holds. So I'm going to push back on that, and I'm going to make that comment. Prefer Nevada law. Sometimes I would offer a backup, just like a neutral location, which is usually Delaware and New York. But I'm going to say prefer Nevada law. California is statute. You're probably like, I wouldn't know that. How would I do that? That is okay. It is okay if you do not know. I do not know all 50 states. I just happen to know California is wonky, but they're not the only wonky one. But I don't remember what all the other ones are. That's okay. I just know that I prefer Nevada, and if I can't have Nevada, I have a backup. Like I said, I've got 2 backups that I would offer if they don't want to agree to Nevada. So I like to call those neutrals, right? Where we're both going to have to get our butts to New York. We're both going to have to get our butts to Delaware. We're both going to feel the same process of procedure. It's going to make things more equitable and fair rather than it being in my backyard or in their backyard. So that helps there. But usually if you're the customer, you can try and get yours. But this is sometimes the thing that ends up with 2 or 3 back and forths. And you just end up somewhere neutral. All notices. Oh my gosh, they did not clean up their template at all. Do I want email to be considered? I will leave it. But I would add my email. Notice email for Abstract Acacia LLC shall be, and I'm not going to put that on there because I don't want that public for the one that I would do for this situation, but I want to make sure that if email's there, I haven't given them my email on this document. I haven't formalized which email it is. Because if I have staff or somebody else using a different email address, I don't want to go into my staff's inbox and my staff not telling me. I want to know I'm going to get it. Where am I going to get my official information? What inbox am I definitely checking? And so I would put that there and clarify that because they've put email. Sent by fax. I do not do fax. Nope. And it's one of those I've never understood why that was a legally recognized form of communication. On the next day or on the 3rd day if by mail. Yep. Certified, registered, return receipt, requested postage prepaid, or other tracking courier. or I should say with or other third party with tracking and delivery confirmation. That way I could use like a UPS or FedEx or somebody else or overnight courier instead of it having to be, because certified mail, registered mail, return receipt mail, pro postage, prepaid, those are all things with the USPS. Such information must be sent to the respective parties. Be designated, right? So it says that there has to be to the address at the top of the first page, but for email addresses, I'll add that. Entire agreement. This is important to know because an entire agreement says that once we get into a contract, right? If I sign that service agreement with them, then the service agreement is what's now going to control certain things. So I want to know if that service agreement has terms of confidentiality, they are going to override this NDA. But because this is here, the entire agreement, anything I may have assigned to before this is now overridden by this NDA in regards to the confidential information, because that's what this is about. Okay, severability, pretty standard. I like that. I love having severability in my contracts. If you don't have it, strong, that's a whole other thing, but definitely like that there. Counterparts agreed. Assignment, nobody may do anything. Yep. Waivers, yep. Signature page that follows. Okay, this is a long, that should be cleaned up, and there it is. Cool. So that, my friends, was a very long-winded, but now you see what I do when I am reviewing an NDA from somebody else. What am I looking for? A key thing to know with all NDAs or any documents you review is there's no level of perfect. I know we say that in general, like there's nothing that's perfect. There is nothing that's perfect on a document either. There might be a comma missing. There might be a period. What matters is the impact it's likely to have on this relationship, right? This NDA, this document template they sent me, I would treat this differently if I was going to be giving personally identifiable information with financial information, because I'm going to care a lot more about how that information is handled because it's managed differently under the law, but also my sources of that information. Where here, I'm just giving my website information before it goes onto a website, my design, my brand, things that are pretty much going to end up in the public for the most part. They might end up with some information about how I work and my products and my business model, but majority of what they're going to have access to will become public. So my concerns here are lowered. There's nothing they're going to receive from me that could be truly detrimental unless they share it too early or sell it to my competitors, things that the NDA in general are going to prohibit. So because of that, I normally would not go in this level of detail for this type of a document. I would have just kind of skimmed it for the main key things. But I wanted to walk you through how things can really get in there. When I do this NDAs these days, I'm usually through them in 5 minutes. But that more sensitivity to the information, the more likely a leak of that information is going to harm you, harm your business success, harm your reputation, and so on. You want to give more detail and care. But knowing that there's no such thing as a perfect document, sometimes done is better, but it is important to know that it is meeting some minimum standard based on what you need it to. An example would be when I started in my career, I always got NDAs, always. I spent about 2 years of my career focusing majority on NDAs in technology and consulting. And I could find sometimes as many as 25 mistakes or 25 red lines on a page, right? And if I have a 2-page NDA, that's like 50 errors. And it's like, look, getting this signed is more important than some of that, but not all of it. Here's how you look at it. If something were to go wrong, what are the odds that this is the part that goes wrong? In the event something goes wrong and it is this part, what is the worst that can happen to us if this gets left this way? There are times the answer to that question is we could go bankrupt. Then you need to get in there and you need to fix that. There are other times that it's like, it's just going to be a friggin' headache. Whatever, a headache's a headache. Do you want to guarantee a headache now by making it more difficult, or do you want to just deal with the headache if it happens? Right? It's better just push that headache down the road. So balancing this, and I've had some really interesting opposing counsel on some documents before where they get so detailed about things, and I'm like, look, We could have been through this entire relationship, had our trial agreement in place, had you sample the data, the product, the information. We could have had our consulting conversations already and been halfway into this project. But you're caring about something that is very, very unlikely to go wrong. And if it does, you really think we're going to sue you over that? And that suing is going to be so big. Like, it just became practically unreasonable. And when I started to show them, I was like, stop trying to have a perfect zero risk document. That's not realistic. What makes sense here? What is likely to hurt the most? That's what you need to stop and protect. And then let the little things be the little things, but make sure those big things are handled correctly. And for me on this document, I've definitely done above and beyond what was the core pieces, but we did find some things in there that I was like, hey, I don't want you making decisions about my information. I make those decisions. And so we've gone ahead and done that for all of you. All right, all that is what it is to review another party's NDA. This is Acacia Thornton, the CEO Legal Coach. If you do need a free NDA, a mutual NDA, I have one available at ceolegalcoach.com/free